Good evening and welcome to Express Updates. I am Josephine Lai. Now to our headlines making news today. Government endorses 5-year presidential term. Age limit cut to 35. Also, GRDA warns public against illegal railway land transactions. These and many other stories coming your way shortly. Please stay with us. Now on to our first story. Government has endorsed proposals to extend the presidential and parliamentary terms of office from 4 years to 5 years. Attorney General and Minister for Justice, Dr. Dominic Ayine, announced the decision while presenting the government's white paper on the Constitutional Review Committee's recommendations in Accra. He said the longer term would give government more time to implement and access their policies, as the current 4-year cycle is heavily affected by transition and election-related activities. Dr. Ayine also disclosed that the government has agreed in principle to reduce the minimum age for presidential candidates from 40 to 35 years instead of the 30 years recommended by the committee. The proposals will undergo the required constitutional amendment process before they can take effect. Still on legal matters, the Attorney General has announced plans to challenge the Court of Appeal's decision to acquit former Chief Executive Officer of Microfinance and Small Loan Center, Sedina Atinu Tamaklo, of all charges brought against her. A case the appellate court ruled that the prosecution has failed to present sufficient evidence to meet the legal threshold required to sustain her convictions.
Sedina Tamaklo was convicted by the High Court in April 2024 after a trial that commenced on January 30, 2019. She was sentenced to 10 years imprisonment after being found guilty on multiple charges arising from her tenure as Maslock Chief Executive and had faced 78 counts, including stealing and conspiracy to steal, willfully causing financial loss to the state, causing loss to public property, improper payments of public funds, unauthorized commitment, and money laundering. Reaction to the judgment, the Office of the Attorney General and Ministry of Justice announces plans to appeal the decision of the court, emphasizing that the office remains committed to due process of the law and is confident the appeal before the Supreme Court will succeed. His statement follows the Court of Appeal's decision to overturn Ms. Tamaklo's 10-year prison sentence and acquit her of all charges, a victory her lawyers celebrate. However, former Attorney General Godfred Yeboah-Dame has expressed disappointment with the Court of Appeal's ruling, demanding explanations from the Attorney General.
Well, have you sought a comment from the Attorney General? Seek a comment from the Attorney General, because Sedina was convicted on very credible evidence and all, and he conducted the appeal. So find out from the current Attorney General what he feels about the acquittal of Sedina and why Sedina was acquitted. I don't know why she was acquitted. So find out from the current Attorney General why that happened.
But we are told that at the High Court, it was not, you didn't prove your case beyond reasonable doubt.
It cannot be the case at all. You see in the judgment of the High Court, yes, Sedina actually absconded after she had actually been confronted with the evidence led by the prosecution. It was not for nothing. So I'm saying, find out from the current Attorney General. You know the kind of opposition that he mounted to the appeal? Or was there any opposition at all? I don't know. That's it.
Is all going well with Hanan's case?
Yeah, as far as we know, yes.
You sought to halt proceedings and to go to the Court of Appeal.
That was dismissed.
Yes, and unjustifiably, as far as I'm concerned, because the matters that we raise are very fundamental. The charge sheet is very defective, but defective not only because of 2 counts that the judge struck out the last time. Is the whole of the charge sheet is defective, and I think it's important that the Court of Appeal determines it, and we have filed an appeal and repeat the state of proceedings. It's important that we know that when the state of proceedings is refused at the High Court, we can repeat it at the Court of Appeal. So we did repeat the stay at the Court of Appeal.
You didn't seem pleased when the charge had indicated that he'd be sitting throughout the legal vacation, especially after getting a circular from the Judicial Secretary?
Yes, because that's unjustified haste, and that is unprecedented. It has never happened at all. I don't understand why they are in such ambulance haste. I mean, in the days of the MPP and all these trials were going on, did you see any of them being conducted in the vacation? Never at all. Never at all was any person tried in the vacation. Has never happened since 1982, and I do not think it should happen. And indeed, we protest the directive given by the Chief Justice for it to happen now. Why? What's the circumstance here? Why so much urgent need to have accused persons tried in the vacation? If we've not been able to try Hanan all along, it's not my fault. It is their own doing that they discontinue the prosecution and all that. If all the charges have been defective and they decide to withdraw at one point and come back, and they have been ordered to amend and all that, it's their own doing. It cannot be as a result of my default. And so there's no justification for the order for the accused persons to be tried in the vacation. We are going to protest the directive, and we'll do so accordingly.
I mean, back to the said now, will you advise the Attorney General to appeal the decision of the Court of Appeal?
Oh, definitely.
Meanwhile, the Attorney General, Dr. Dominic Ayine, has also reacted to the judgment, maintaining that the state established a solid case requiring the former chief executive to answer for the financial losses incurred by the agency.
This morning, the Court of Appeal issued a decision unanimously acquitting and discharging Sedina Atienu Tamaklo, who was convicted of various offenses in absentia because, she was standing trial, and in the course of the trial, she sought permission to travel abroad for medical reasons and then remain in the United States for the rest of the trial. The trial court convicted her of the offenses charged, and then an appeal was filed by her lawyers in May 2024. I want this to be made abundantly clear that it was my predecessor who filed the appeal. However, coming into office, I reviewed what was filed, and I directed the Director of Public Prosecutions to file opposing the appeal, because we believe that the High Court judgment had merit. Now, with this judgment, I've also directed the Director of Public Prosecutions to file a notice of appeal and apply for stay of execution, meaning that if the stay is granted, the status quo will prevail until such a time that the Supreme Court has had time to review the appeal and then made a determination. So that is all that I can say for now. I have a soft copy of the judgment. I'm yet to peruse it and then come to a firm conclusion as to what will be our grounds of appeal. But I want to emphasize that I believe that the judgment of the High Court had merit, and that the United States District Court that extradited her to Ghana had a basis for making a determination that she was the proper subject for extradition. And that is all that I will say for now.
In other news, the Ghana Railway Development Authority has cautioned the public against purchasing or leasing railway lands and buildings from individuals without its official approval. The warning follows reports of an alleged illegal sale and lease of railway properties in parts of the Western North, and Ashanti regions by some individuals, including former employees of the defunct Ghana Railway Company Limited. In a statement, the authority said the transactions are unlawful and violate the Railways Act and the Public Financial Management Act. It added that investigations have uncovered attempts to backdate transaction documents to make the deals appear legitimate. The authority urged the public to verify all railway property transactions with the Ghana Railway Development Authority before making any commitments, stressing that it will not recognize or regularize unauthorized agreements. On our last bulletin, the Executive Secretary of the National Labour Commission, NLC, Dr. Bernice Anoa Welbeck, says the Commission has successfully resolved more than 13,000 labor cases over the past 20 years. She made the disclosure at the Stakeholders Symposium held in Accra on Wednesday to mark 2 decades of the Commission's work in promoting industrial harmony and resolving labor disputes in Ghana. The symposium themed 2 decades of the work of the National Labour Commission, lessons, experiences, challenges, and the way forward, brought together key stakeholders to reflect on the Commission's achievements, share experiences, assess emerging challenges, and discuss strategies to strengthen labor administration and industrial relations in the country.
Leave-related issues, including maternity and sick leave, formed a significant portion of complaints in the Commission's early years.
A total of 730 cases were filed or were handled by the Commission in respect of dismissal. In respect of unfair termination, 885. Retirement benefits, end of service benefits, 278. And paid salaries through overtime pay, 337. Workmen's compensation as non-payment or non-reported, 71. Redundancy pay, layoff servants, 206. Medical, 10. Leave entitlement, sick leave, maternity leave, 3,272.
Unfair termination consistently topped the list of cases brought before the Commission over the years.
Between 2010 to 2014, a total of 3,455 complaints were handled by the Commission. I'm not going to walk through them so that we don't spend so much time. Now, then 2015 to 2019, a total of 3,638. In all of the statistics that I'm giving, you would see that when it comes to dismissal, for example, 2010-2014, 734, unfair termination, 1,013. 2015 to 2019, dismissal, 761, unfair termination, 1,109.
This brings the total number of labor and industrial disputes handled by the Commission in its first 2 decades to 13,113.
A total of 2,778 cases were handled by the Commission. And again, we have dismissal 336, unfair termination 973, retirement, end of service benefit, and so on. So now, total number of cases recorded from April 2005 to December 2025. So 2005 to 2009, 3,242 cases were handled. 2010 to 2014, 3,455. 2015 to 2019, 3,638. 2020 to 2025, 2,778. So from April to December 2025, the Commission handled a total of 13,113 complaints.
Disputes arising from the ending of employment relationships through dismissal, unfair termination, or redundancy formed the largest share of cases at 58%. The Commission also recorded cases of workers kept as casuals for as long as 15 years and industrial actions declared without following the legal 7 days notice.
Over the past 20 years, unfair termination recorded 30%, retirement, end of service benefit 4%, unpaid salaries over time 13.5%, workmen's compensation, non-payment or non-reported 2%. Then redundancy pay, layoff severance 8%, medical 0.4%, leave entitlement, sick leave, maternity leave, and maternity 23%.
The Commission pays out between 800,000 Ghana cedis and 1.2 million Ghana cedis in compensation to workers every year. Dr. Warbeck noted that many of the disputes could have been avoided with better human resource practices and strict adherence to the Labour Act.
Facilitation by the industrial relations officers, which outcome is agreement, the success rate was 64%. Mediation. Commission appointed mediators. Again, the outcome is agreement. The success rate was 77%. Arbitration, whether voluntary or compulsory, by commission appointed arbitrators or members of the commission where there's a compulsory arbitration panel which results in the making of award. The success rate at settlement was 100%. And then adjudication or summary settlement, members of the commission hearing the matters, issuing directives, decisions, rulings, and orders, the success rate was also 100%. Overall settlement record. Of the 13,113 complaints handled during the period, these are the records. 12,677 fully settled and concluded. This includes 43 cases which are in court for enforcement and those appealed against. 317 still going through the initial process of resolution, that is facilitation. 119 cases unprocessed due to lack of response, but to be processed in due course.
The Executive Secretary also praised the immediate past commission for clearing a significant backlog of cases and raising standards as the National Labour Commission. This is all we have for you on Express Updates. I am Josephine Lai. Do enjoy the rest of our programs.